Morning, everybody. Welcome to October somehow already. This is October's coffee break briefing, looking at the Employment Rights Bill and what is likely to happen over the next couple of years or so. As always, the session is being recorded. It will be circulated to everybody who has signed up or registered for it. And as you know, copies of this and indeed all the previous coffee break briefings, both done by me and any other colleagues at the firm, are all available on the Frettons YouTube page. Again, as always, please make use of the chat Q&A throughout the session. I will try to answer questions as we go, but there is a lot of information I want to get through today, so I can't guarantee I will get to absolutely everything. Sort of the structure of today's session, really, I am trying to do in an hour what my entire team did in 3 hours together last Wednesday at our in-person event. So please do bear with me. It will be quite a very brief, very quick introduction to a lot of the things that we know are likely to happen over the next couple of years. And in terms of structure, what I thought I would do is run through the proposed implementation roadmap, looking at when things are likely to happen over the next couple of years. And then in the second half of the session, focus on some of the key elements that I know people are interested in, and also a couple of the things that are likely to crop up most immediately. Please also bear with me, those of you who've spoken to me in the last couple of weeks. I've not been feeling 100%, so if I do have a coughing fit halfway through this, I do apologise. Anyway, moving swiftly on to get through as much as we can today. What I thought would be particularly helpful and why I wanted to do this session today is because of where we are with the Employment Rights Bill. We have had the roadmap to implementation issued by the government a few weeks back, now telling us what they're expecting to implement and when. It strongly indicates that they are intending to implement the Employment Rights Bill, Employment Rights Act B, in the format that it has currently last been drafted, really. If you read that implementation, it's very clear that despite some of the proposed amendments that came from the House of Lords in the last month or so, the government's not intending to agree to most of those. They are looking as though they're likely to push it through exactly as previously drafted. A date has been given for the final House of Lords vote now. I think we discovered this yesterday, so 28th of October. Anybody who really desperately wants to follow this and watch the House of Lords live to see how they vote on it, I won't be, but please do. That means it is very likely to receive royal assent later this year. I can't imagine the House of Lords is going to do anything other than rubber stamp now at this point. I may well be wrong on that, but I think unlikely. So we've got the roadmap, we've got the government telling us what they're intending to do before it's even become law yet, but I think realistically we can safely assume that it is going to be law in the way currently drafted. So let's think about the things that are going to happen immediately. And don't forget, over the course of the next 2 years, before I touch on these, we are looking at some fairly significant stuff under this bill. We've got changes to 0 hours working. We've got updated rights in relation to flexible working. We've got better protections for people on pregnancy, maternity related or other family friendly leave. We've got developments in diversity, transparency, reporting requirements, changes to collective redundancy consultation to think about, the effective ban on fire and rehire arrangements, huge changes to trade unions and their ability to access the workforce and gain recognition. The sexual harassment preventative duty becomes all reasonable steps alongside the introduction of third-party harassment. We've got new rights in relation to paternity pay, unpaid parental leave, bereavement leave, day one unfair dismissal rights, the new statutory probation period, changes to how statutory sick pay operates, changes to rules around tipping policies and practices there, and one that I will not be covering because it is quite dull. Please talk to us separately if you really want to. More regulation of umbrella companies. So, as I say, my plan for the rest of this morning is to work through this somewhat chronologically for the first 25 minutes or so, and then do a slightly deeper dive on some of the key issues that are likely to rise for all of us over the next couple of years. So, starting with the stuff that sort of happens immediately or shortly after royal assent. Almost all of this happens the moment the document becomes law, or by a short implementation period not long afterwards. Hopefully, these are not going to affect too many people, and I don't think too many people on the call are particularly concerned about sort of the first two of these. Just a brief warning, I will be talking quite a little bit about trade unions today. I appreciate the immediate stuff is not going to be very interesting for those of you who aren't actively engaged with trade unions, either in your existing workforce or companies that you work with if you're an external HR consultant. But the stuff I start talking about for the first couple of slides on this over the next 6 months or so is going to start to have an impact later. And I think the underlying message with trade unions is we have a Labour government now. Expect the shift to start to move back towards power and recognition on their side of the equation. Anyway, immediate stuff hopefully won't affect too many people. The Minimum Service Levels Act was one of those slightly rushed pieces of legislation towards the end of the previous government that was designed to ensure that core infrastructures didn't shut down in the event of particularly public sector industrial strike action. It's never, to the best of my knowledge, been particularly effectively enforced. A couple of weeks ago, I had to make my way from St Pancras to Waterloo in the middle of the RMT strike, so I know fully well that the tube was not operating at that point, and also discovered that during rush hour that walk is possible in just under 50 minutes. I did catch my train, be pleased. The later train was delayed, of course, but I did catch that one. So I think that one, it gets repealed. Like I say, it's never really been particularly enforced strongly, perhaps more so around the NHS side of things, but that minimum service level requirement for those of you particularly involved in the public sector, that will go, as will the majority of the Trade Union Act 2016. That was a piece of legislation which, again, if you don't have trade unions active in your workforce, you probably didn't even notice that one coming into play. It introduced some fairly restrictive requirements around balloting and the obligations on trade unions to provide notice of industrial action and all of those sorts of things. Introduced by the Cameron government, second Cameron government, I think 2016, realistically not going to make a huge change to most people, save for how it then impacts later on. Legal protections for people engaged in industrial action are extended to the entire period of any strike that's taking place. They're currently time limited, but you'll see later there's also an extension to the general mandate around ballots for industrial action. And at the same time, we get some relaxation of the balloting rules in the first place, which helpfully does make life easier for trade unions who are already in place to reach threshold for strike action. The introduction of electronic balloting in particular, designed to make it easier really to ballot an entire membership as straightforwardly as possible. And that's really it in terms of the immediate stuff. But I think what we have to bear in mind is, as a consequence of all of that, what we're seeing is that first step towards unions getting some of their negotiating power back. This makes balloting and indeed subsequent action easier for trade unions who are already in place. So as I say, watch this space. That's fine for the ones who are already there. We've then got some changes coming up for unions who want to be in the workforce. So stuff that is going to start to affect us towards the start of next year, and this is where it's sort of going to roll into those of us who actually need to start doing things, I think, really. So those of us not particularly concerned with the trade union stuff, first major changes that we will see, and the first major changes that affect everybody as of April next year. The running theme, by the way, for those of you who remember this, is we do seem to be going back to April and October updates and changes. It's a lot in the next couple of years, but it is these sort of 6 monthly rollouts to at least give us some time to prepare for implementation of all of this. So what happens in April? Changes to collective redundancy consultations. The particularly important one here is the increase to the penalty award for a failure to correctly engage in the consultation process. That doubles. So currently, per affected employee can claim up to 90 days by way of a compensatory award, protective award, for a failure to properly engage in a collective consultation. That doubles to 180 days pay, which is a fairly significant increase, and on top of the unfair dismissal claim, pretty good motivation to ensure that you are consulting collectively properly. The one thing that is interesting about collective consultations in relation to redundancy here is that there does appear to have been a backtrack on the establishment rule. So at the moment, it looks as though we're keeping the single establishment concept. Bear in mind, they could well throw out a regulation between now and next April to impact that, but the latest version I have seen strongly suggests that we are keeping this single establishment rule that we're all used to. Yes, it's complicated. Yes, the definition of an establishment has been disputed up to pre-Brexit European court level, but it's there. And on the plus side, at the moment, it looks as though we don't need to worry about that collective consultation being the entire workforce across every location. Starting to make some changes then to things around pay and leave entitlement, paternity and unpaid parental leave. We removed the service requirement to be eligible for paternity leave. I really don't think that's going to make a huge amount of difference to most people anyway. If people are going to get a day one right to paternity leave, then I think so be it. I don't think that's suddenly going to cause a massive increase in a huge number of workforce taking leave. Naturally, all of the other requirements are still there, least of all that they have to be a recent father. Hence the suggestion it's unlikely to make a huge difference. Similarly for unpaid parental leave, this is in addition, by the way, to unpaid parental bereavement leave. That right crops up from day one as well. And again, I don't think a massive disaster for people taking a period of unpaid leave as a period of absence potentially from day one. Obviously bigger issues in relation to day one rights coming up over the course of a subsequent year. We see the introduction of the Fair Work Agency. I will talk about this potentially in a little bit more detail later on, time allowing, but I think what's interesting about the Fair Work Agency in particular is there was a lot of talk about this being quite a serious centralised enforcement body for statutory employment rights. That, from what I've read, doesn't appear to be the case. There's not a huge amount of information about what it is or what it's supposed to look like, which is really helpful, I know. But the focus at the moment seems to be bringing under one roof areas which are dealt with primarily by other enforcement bodies at the moment. So it's going to be things like national minimum wage, statutory holiday pay, those things where there are active, flagrant, deliberate, exploitative abuses of statutory rights. And it seems to me that the intention, as I say, is to bring them under one roof and to centralise them into a single agency. I think the primary concern with the Fair Work Agency is going to be around the modern slavery definition and the deliberate abuses of employment rights. I think it'll take a very, very long time for them to merge into the kind of agency which it was suggested they could be. I don't think they're going to be turning up to the average workforce and workplace, and immediately demanding to see all of your holiday records. Least of all because this is a brand new government agency on which there has been no serious discussion so far about how it's going to be funded or resourced. So if nothing else, it doesn't look as though they're going to have the people to do it. Forget anything else. The next big major change is absolutely going to affect almost every employer immediately from April. We're used to changes to statutory sick pay hitting in April, usually the pay rates. Next year, we're going to see the qualifying period, or most of the qualifying criteria really go. So lower earnings limits. We know that most people have to be earning at least basically national insurance threshold in order to be eligible for SSP, and also that initial 3-day waiting period. What this effectively means, SSP becomes payable to anybody who is employed, who has done some work from day one, regardless of how much they're earning for you. I'll talk about SSP in a little bit more detail later because it is the first one that leads to contractual policy and procedural changes for everybody. But that's the headline story. More people are going to be eligible for it. And that, I think, is the first thing that everybody is going to have to do, regardless of whether anything else I've spoken about so far affects you. More on trade unions here. So I talked immediately about these slightly easier balloting rules, these slightly easier to reach industrial action thresholds kicking in immediately. By April next year, we start to see a move towards increased recognition. And this, again, should not be a surprise. We've got a Labour government, and I think particularly with this one and day one rights, regardless of the fact that Angela Rayner is no longer a senior cabinet minister, was clearly driving some of these points. These are going to go through in the way drafted. Very briefly on trade union recognition, I could do an entire hour on this alone. There are currently 2 procedures for it. Voluntary recognition, which if you know the trade union doesn't have support, there is almost no reason for the average employer to agree to. And how that works, very briefly, the union comes to you and says, we'd like to be recognised. You're probably going to say no. If you do say yes, you're going to enter into some kind of negotiation process about the extent to which you agree to the union being involved in discussions around changes to terms, pay, salary, those sorts of things. And if it's agreed, it's drawn up as a voluntary agreement and signed off by the Central Arbitration Committee, the CAC. If it's not agreed, then there's some quite onerous requirements on the trade union to prove that they are supported by a significant number of people within the bargaining units, the group of people they say they represent, and that the vast majority of the workforce, broadly speaking, is in support of recognition. If they can show all of those things, they can make an application to the Central Arbitration Committee for what is ultimately forcible recognition. Forcible recognition, as with sort of most court, tribunal, arbitration bodies, is generally not ideal for the organisation that it's being enforced against. There are fairly standard template terms for what a recognition agreement will look like when it's imposed. So the general rule has been, if you know your union has reached those quite high thresholds that already exist, it's always worth engaging in a conversation with them to look at what recognition might look like voluntarily. The problem with this is it significantly reduces those thresholds that the union would have to prove for forcible recognition for the statutory process. Ultimately, there is currently a 10% membership requirement of the bargaining unit, and to demonstrate both that there is an actual majority in terms of what the ballot would be for recognition, and also to demonstrate that at least 40% of the workforce generally would support recognition. What this does is it removes and lowers basically those thresholds. What it will become and what it looks like is drafted at the moment, that 10% could become as low as 2. There are regulations in place to amend that to a figure anywhere between 2 and 10%. And then the only other requirement being to show that they have a majority of actual votes cast in a recognition ballot. And what that basically means is if you've got a union who represents a fraction of your workforce and a relatively low number of them are in support vote and a majority are likely to vote in favour of recognition, it's making life much easier for the union to go down mandatory recognition through the CAC route. What I have been saying about this so far, and I think we're all going to have to get up to date on trade unions, if you are already in a workforce where trade union recognition is, or certainly membership, is reasonably high, start thinking now about those conversations and alternative methods of workplace representation. Staff who feel as though they are already represented and listened to are less likely to unionise, but if we know the unionisation process is going to be easier for them, it is still preferable to have some kind of voluntary arrangements in place beyond it being imposed on standard terms. I know some of you are in somewhat unionised workplaces, and I will say now that sort of manufacture, hospitality, the care sector, unfortunately, you do not do very well under this bill at all, and this is one of those areas. I can always have separate conversations with people about that, and if there is, by the end of this, an interest in doing a separate section entirely on trade union rights moving forwards, I'm happy to explore that, but I obviously don't have time to go through it all now. So rolling into October of next year, so we're talking things that are going to happen in sort of 12 months time or so, probably, and we start to get some of the bigger stuff, I suppose, and the things that are going to give rise to new claims. So the effective ban on fire and rehire practices. This comes on the back of all of those very, very unpopular and high profile fire and rehire processes and court cases, P&O being the big one. Tesco went all the way through to, I think, the Supreme Court on a case that I talked about, trying to change pay terms under a contract, and that triggered fire and rehire issues, including whether or not they could get an injunction to stop the dismissal in the first place. What this legislation actually does is introduces a new form of automatic unfair dismissal. What it broadly says is it will be automatically unfair to terminate somebody's employment for a refusal to accept a change of contractual terms. In effect, what we generally recommend people don't admit to fire and rehire for, but the purpose of fire and rehire almost always being to change contractual terms. There are very, very limited ways of getting around that. And ultimately, the only one that is really clearly in the legislation will be the alternative to imposing that contractual change, was that the business would shut down financially. It's comparable. Those of you who've gone through it may know the defence to a TUPE consultation is sort of very extreme extenuating circumstances. You can sometimes get around a full consultation process by saying, look, if I hadn't done this within 2 days, the business would have shut down. It's a similar kind of argument here. It would have to create a situation where the business will implode if we don't impose this contractual change. The difficulty with that, of course, much as it is with the TUPE consultation defence, it's going to be very, very hard to say we couldn't see this coming, and therefore we didn't have an opportunity to do alternative steps. The other big change towards next year, of course, we've already got the preventative duty in relation to sexual harassment. So that is the duty to take reasonable steps to prevent it. I won't be going through sexual harassment and what that duty looks like in a huge amount of detail. Anybody who didn't join last month's session, Justine and I talked about that for the entire period. It is on the YouTube page. Go back and watch that one if you want to sort of get some ideas on what we think around reasonable steps. And also ultimately all reasonable steps. But the important thing to take away from this, October next year, the current reasonable steps defence becomes all reasonable steps. I will talk about it a little bit more towards the end of this session in what will become the second half. But I think that word all has been batted back and forth between the Commons and the Lords. It's been debated within the Commons, within government. It's a very, very deliberate inclusion. It's a very, very deliberate step up from reasonable steps. At the same time, we see the introduction of third-party harassment. This has probably been one of the more controversial elements that's been included in the Employment Rights Bill. And the reason I say that is ultimately it introduces a cause of action for an employee or a worker, or indeed, I suppose, for a self-employed individual in principle, if they experience harassment by a third party. So this is somebody over whom the employer has got relatively little control. So it could be a contractor coming on site, it could be a member of the public. In principle, and again, I'll talk about this in a little bit more detail later, overlapping with the sexual harassment point, it could be somebody working from home who feels harassed by a partner or a family member. So there is an awful lot to consider when thinking about this overlap of all reasonable steps for sexual harassment and indeed third-party harassment. That is one of the ones I'll talk about in more detail later. More on trade unions towards the end of next year, the duty to inform of the right to join. Now, at the moment, this looks like it's going to be a line that goes into the Section 1 Statement of Terms. So an amendment to your contracts, which hopefully will be something that you can tuck away in Clause 27, B3A4, which says something like you have the right to join a trade union. I'm pretty sure there will be further amendments so that there will be some kind of regulation. I think the thing that is least clear about this at the moment is, given what we've just been saying about recognition, is whether in the event that there is a recognised trade union, you will have to signpost towards that or those unions should they exist. A little bit unclear at the moment, but again, it's one of those ones to be mindful of because it is yet another contract change that will need to be implemented at some point next year. Yet another step with trade unions, and this is now all about access. So the current position with trade unions accessing your workplace and your workforce is basically they can't. You know, if a trade union turns up in your office and says, I'd like to talk to your staff about membership, you are quite rightly going to tell them to go away. And you can do that, and there's absolutely nothing wrong with that. What the Employment Rights Bill introduces is an increased way for trade unions to access your workforce for the purposes of everything from recruiting, engaging in collective bargaining, representation, even to non-members, and simply raising awareness of the existence of the union in the first place. It does require some form of access agreement to be in place. But I think when I say access agreement there, you need to think about it very similarly to recognition. The plan for access arrangements sort of mirrors the approach to recognition. You can either have a voluntary arrangement, or the union will be able to make an application to the CAC to compel access in some way. And again, I think this is one of those situations where it's very much carrot and stick with significant motivation to take the carrot. It's much better to have an access agreement that you have had some control over and some kind of influence as to what it looks like, than to have to go down a court process and have access compelled on you. Again, I will talk about that in a little bit more detail, because I appreciate trade unions is one of those areas that some people will be more interested in. We've also got some changes in relation to facilities use. So it introduces an obligation on you for an individual who is entitled to time off during the working day to take part in trade union activities. So that is the internal trade union rep. Access to facilities, the right to use those facilities for the purposes of undertaking their duties or trade union activities and training. Little bit unclear as to exactly what this is going to mean. The legislation currently uses the word accommodation and other facilities. Whether that means you have to pay for them to have 5 days in the Savoy if they get called up to do a training exercise in London, I think unlikely. But I think it will almost certainly extend to a private workspace to undertake their duties, to talk to staff who might be interested, and particularly in relation to representation. Similar right for a trade union member who is also an equality representative and is undertaking equality duties. And this again is all about making sure that trade unions have access to the workforce, can effectively engage in what they are there for, particularly in relation, I think, to representation, and sort of almost this third-party auditing type role that equality reps sometimes seem to assume. We've also got a slight change in the law to fill a gap coming in here: protection against detriment for taking part in industrial action. It is a very, very weird quirk of the law that came up in a largely unheard of case. You obviously can't dismiss an individual for taking part in industrial action for the most part, but there is a gap that basically says you can, in theory, submit them to a detriment. So in theory, you could refuse to promote somebody because they had taken part in a strike, which seems an odd gap in the law. And this is exactly what the courts concluded. They said it's probably not compatible with the Human Rights Act, but the way UK law works, they can't overturn legislation or say that legislation is incorrect. They can only say this is the position. So October next year, we fill a gap, which basically says you now can't do that moving forwards. I'm not suggesting for the next 12 months that you start subjecting people to detriment of taking part in industrial action. That will almost certainly give rise to a constructive dismissal claim and possibly also some kind of other detriment or discriminatory claim, depending on the membership. But in principle, it's something that could be done. Again, if you haven't got active workforces taking part in industrial action, then it's sort of neither here nor there for the time being. Another complication, just to make all of our lives easier, the employment tribunal limitation period increases from October next year. So as we know, most claims 3 months, less a day, plus the ACAS period. If you want to know more about that, watch, I think, the very first or possibly second one of these that I did on the employment tribunal process, which covered ACAS periods and time limits. Currently that period, so we get the 3 months from the date the thing happens, we get 6 weeks with ACAS, and we get a month or two for the tribunal to sort themselves out and actually remember to send you the claim form. So realistically, 6, 7, maybe 8 months after the event takes place, you can generally start to consider yourself to be somewhat safe if you haven't received a claim form yet. This extends to 6 months, presumably still subject to the ACAS period. There's no reason to suggest that's changing. And indeed, an increased number of claims will no doubt increase the amount of time that it takes for the tribunal to process them. This ultimately simply means you've now got at least a year after an event before you can probably consider yourself safe. We know that ACAS sometimes don't even manage to contact people within that 6-week period, so you may not even be aware of it then. And I've had at least one claim where the claim form didn't arrive with my employer client until over a year after it was issued. So yes, all fine and good saying we've got this sort of very short period at the moment. Simple answer, it's going to be longer. It's going to give people more time to think about whether they want to issue a claim or not. On the plus side, it also gives us 3 extra months to try and resolve it in a way that doesn't involve going to the employment tribunal. I won't talk in a huge amount of detail on the changes to tipping practices. For those of you this does affect, and obviously that's primarily going to be the hospitality sector, most of you will already have engaged with the allocation of tips legislation that came in 2023, 2024. That required you basically to have some kind of written policy around how allocation works. The new rules don't significantly change that. They don't change the rules about how it's treated for tax or distribution purposes. It doesn't change trunks, anything like that. What it says is, before the first version of a written policy is produced, you have to engage with staff representatives, trade unions, or staff individually. That policy must be reviewed at least every 3 years, and there are rules about the consultation process for that coming in as well. For those of you in that sector, if you want further guidance on that, please do let me know. I can send you a summary, or of course, no doubt there'll be additional regulations about what that has to look like coming out in the next 12 months or so. But it does, for some obscure reason, introduce quite an onerous 3-year review and consultation process. What I think is interesting about that, of course, is we've got a statutory requirement to review a tipping policy every 3 months. I think that strongly indicates what the government's view is on how often all policies should be reviewed. Probably much more frequently. And finally, all the stuff that happens beyond 2027, and this is where, or I suppose 2027 and beyond, I should say. Firstly, having been in place since October of next year, at some point in 2027, we will be told what all reasonable steps are. Thank you to the government for that one. Some version of this will have been law for almost 2 years by that point, because of course reasonable steps is in place already. So that's really helpful to us. What the defence around this says, and the claim, of course, is the failure to take all reasonable steps to prevent. It says that you'll be able to defend the claim if you have followed what the government, by the time these regulations have rolled out, call all reasonable steps, insofar as they apply to your workforce, and anything else specific to your situation. Again, I'll talk in a little bit more detail about this further, and again, we talked about it in a previous session, but really, this is the time to start thinking about this, to start engaging with staff, to start deciding what those steps might be, and to start looking at risk assessments. It is coming in next year one way or another, and if you haven't already done a risk assessment for basic reasonable steps, you really need to start thinking about it for when that upgrades. Equality action plans, a new obligation for large employers, so that's 250 or more employees or public authorities, to publish an equality action plan showing the steps they're taking in relation to their employees with regards to matter of gender equality. And there is a lot of talk around this, particularly around things like menopause action plans, diversity at executive level, and to publish any prescribed information using the existing platform. Rights on dismissal for pregnancy and various forms of family leave. It appears to be a 6-month protected period after return, which may well limit the scope to dismiss at all within that period, without there being some kind of presumption that it was due to having taken the leave. More regulations to follow on that one. Bereavement leave, again, it provides for regulations to be introduced at some point in the future to give an entitlement to employees who are bereaved to take protected time off work. This would be in addition to the existing provision for parental bereavement leave, but does apply to everybody. So a bereaved person will be defined in regulations to follow by reference to the employee's relationship with the person who has died. Fixing a slight quirk, paternity leave after a period of shared parental leave. This just fixes that weird situation that sometimes happens where in theory paternity leave has to be taken immediately after birth or within 52 weeks. For anybody who has had to sit and calculate shared parental leave, I wish you luck, but hopefully this will make life a little bit easier. Changes to 0 hours I'm going to talk about in more detail in sort of the last part of the session, but there is a lot there. Right to be offered hours in a prescribed form, right to notice of shifts, right to notice for cancellation and change of shift patterns, all of which I'll come on to. And of course, the big one that everybody wants to hear about, day one unfair dismissal rights, which I will definitely talk about in more detail. So that is a very, I say very quick overview. It's taken me 35 minutes just to get through what's happening. Like I say, for the second half of the last third, I suppose, of this session, what I want to do is just go through some of the bigger stuff. So I'll talk briefly about the changes to SSP, because that's the first one that really comes in. I'll talk about the 0 hours contracts in more detail. I will talk about possibly the Fair Work Agency if I get time. That might be the one I skip. Harassment, maybe sexual harassment in a little bit more detail. And of course, day one rights. So where should we start? The SSP changes. So I said when I mentioned this one, which we need to be aware of pretty much straight away, that what we are doing here is removing the waiting period and also the lower earnings limit. In practice, therefore, this means that SSP becomes an entitlement for all qualifying staff. So that is primarily employees, although there are some situations where workers may be covered, to SSP from the start of their sickness absence. I think the big thing to be aware of here is this is now going to encourage people to have time off when they might not otherwise have done so. If pay is a concern, the fact that they're going to get maybe 20, 30, 40 pounds for taking the day off that they might not ordinarily have done so is actually going to encourage it to be taken as a period of sickness absence. Now, this is arguably a good thing. It's presumably designed to discourage presenteeism and make sure that people who are genuinely off sick actually take that time to recover. On the flip side, and as most of us will be aware, it may also lead to an encouragement of this idea of persistent short-term absence. I think this is a wonderful opportunity to review how you are approaching persistent short-term absence and to start record keeping people who are making use of this change to regularly take Fridays off. I'm not suggesting that is something employees do all the time, or indeed that it's a particular problem, but some workplaces will tell me that it is. This may well risk making that worse. And like I say, I think it's a very good opportunity to look at how you are recording absence, making sure line managers are aware of the change in the rules, but also what it means, because of course it is ultimately more cost to the business. And in particular, making sure that if you're using third-party systems to record absence and record and calculate sick pay, that it can do all of the calculations it's required to do. In relation to how much people receive, there is also a proposal here that if people earn below the lower earnings level, then what they will actually do is have some kind of percentage calculation instead. It's either, as I remember correctly, the lower of either whatever the statutory sick pay rate is at the time or 80% of their actual earnings. It's the same calculation we're familiar with for other forms of statutory leave. That's all I want to say on SSP at the moment. Like I say, it's one of these immediate things. I think it's about making sure that policies, procedures, contracts are updated to ensure that it reflects these changes when they come in. We will obviously keep you updated through whatever mechanisms we've got available to us as these things roll in. 0 hours contracts. The headline manifesto point here was to ban exploitative 0 hours contracts. Whether the Employment Rights Bill goes that far or not, slightly different question, but it does introduce a requirement to offer guaranteed hours in some circumstances, a right to reasonable notice of shifts, compensation for cancelled or changed shifts, and a new protection from detriment and dismissal associated with sort of asserting any of these rights or a refusal to engage with any of them. So the reforms apply to 0 hours workers, agency workers, and workers on what the government will consider to be low guaranteed hours who regularly work more than those hours. 0 hours contract defined as a contract of employment under which there is no certainty that any work will be made available. So a proper core 0 hours contract. It also covers what is called 0 hours arrangements, which has a similar definition. A low hours contract is not defined, but will come in further regulations. The duty to offer, the employer will be obliged to offer at the end of every reference period, a guaranteed hours contract to a qualifying worker, which includes agency workers, that reflects the hours actually worked. A qualifying worker will be somebody on one of those contracts who regularly works more than the minimum hours specified in that contract during a reference period that looks likely to be 12 weeks. This means at the end of each reference period, employers will be required to offer an affected worker a contract guaranteeing them hours to reflect the actual hours worked in that period until they are no longer a qualifying worker. It's a complicated mess, really boiled down. Somebody who is on a 0 or low hours contract who regularly works a working pattern over 12 weeks that is more than those hours has the right to be offered what is in effect a fixed hours contract. Employers must either offer to vary the worker's existing terms to guarantee the hours worked or issue a new contract, and you cannot make any other changes as a part of that fixed term contracts, which is a natural solution to this, could only be offered where reasonable in very limited circumstances. The right to notice is reasonable notice of shifts to workers who are on one of those other specified contracts, including agency workers. The notice must state the date of the shift, the start and end time, and the number of hours to be worked. Similar requirements apply if a shift is cancelled or changed, and notice will be presumed unreasonable if it is given less than a specified time before the shift starts. That period is to be set by future regulations. We don't know what it will be yet, but the government has said it is not going to be more than 7 days. If a worker brings a claim for the sort of failure to do any of these, the tribunal has the power to award what is just and equitable in the circumstances. Compensation for loss of shifts, that would be if a shift is cancelled or curtailed on short notice, presumably. The amount of compensation to be set by regulations in the future, it won't exceed what the employee would have earned, or the worker, I suppose I should say, would have earned in that period. And it's likely to be a sliding scale based on how much notice is actually given. Yes, this is quite bad, I think, for the hospitality sector in particular. It's going to require quite a big change to how you work with 0 hours and low workers' hours. The rights that I've just covered will also get a detriment and dismissal protection. It'll be automatically unfair to dismiss somebody for asserting one of these rights, for rejecting or taking a proposal, if you dismiss them for a way of avoiding compliance with this legislation, or if you simply believe that they were entitled to be guaranteed hours and then refuse to make that offer. An employee or worker will also be able to claim a detriment because of being forced to take this, for example, or because they've chosen to accept this, if they have declined a work shift on the belief that you failed to give reasonable notice, or if they bring proceedings in good faith relating to guaranteed hours. And again, the tribunal will have the ability to award what they consider just and equitable in the circumstances. More great news for sort of recruiters and agency staff here. End hirers will be responsible for making the guaranteed hours offer. It won't be the agency, although watch space for further regulations on that. Agency workers, if they are offered and agree this proposal, will enter into a direct contract with the end hirer. It transfers employment from the agency to the end hirer. Agencies can continue to include transfer fees or extended hire periods in contractual agreements with the end hirers. That would be a purely commercial issue between those two entities. For other than where those fixed or permanent contracts have been introduced, the agency and the end hirer can be held jointly responsible for the notice of shifts, cancellation, curtailment, and employment tribunals will have the ability to apportion liability. Agencies will be liable to pay compensation for short notice cancellation or curtailments, and therefore, if you are an agency and you're on this call, you want to consider your commercial arrangements with end hirers and how that can be mitigated, apportioned, or some kind of liability shared between you. This is going to be quite onerous. This is going to be quite complicated. And I think it is going to require a fairly detailed look at how 0 hours workers are being used within your workforce. Sorry, I didn't say this was going to be a fun session for everybody. Briefly on the Fair Work Agency then, I'd mentioned when this was first introduced that the Australians have got an organisation called the Fair Work Agency. We do know it's not going to be them. They're an arbitration enforcement quasi-court body. Broadly, this is what I said earlier. What we do know, this is not going to be independent of government. So it's not a court, it's not a tribunal, it's not an agency like Ofcom. It will be an executive agency sitting under the Department for Business. So therefore, it is closer to, I would say, somebody like the ICO, potentially, advisory, quasi-enforcement, powers to enforce holiday pay, leave, national minimum wage, and probably sick pay rules. For the most part, as I said earlier, it seems to bring all of these organisations that already do these things under one roof. And if you look at what those are doing already, like I said earlier, the focus is really on those sectors where there are flagrant, deliberate and routine abuses of statutory entitlements and basic employment rights. That said, and as I've indicated on the slide there, we all know HR is not a regulated practice. You don't have a regulator sat over you telling you what to do, but you do now, or will now, have an agency within government that's got presumably the power to inspect records and indeed act independently. A complaint doesn't need to have been made in order for them to look into things. So this is a good opportunity to review practices, review record keeping, and ensure that if somebody were to come knocking, you could produce everything you need to. As I said, I'm not going to cover sexual harassment and third-party harassment in a huge amount of detail because I talked about it much more in the previous session. That said, what is the difference with all reasonable steps? Well, firstly, we're not going to be told exactly what that means until 2027 anyway, so that's when the regulations will come in, as I said earlier, to tell us what it looks like. But it is a high threshold. There is a lot of guidance out there already. So in relation to sexual harassment, look through the EHRC's 8-step plan that they've produced. It is quite good. It does give some good ideas. I think the one thing that you are really not going to be able to do here is get away with not doing a risk assessment. That risk assessment is going to have to cover all the particular areas that might affect an employee, worker, or indeed a self-employed person in your workplace. You want to look at things like gender imbalance, the power differences, third parties who might ultimately end up being harassers, home working arrangements, lone working, late night working, all of these sorts of things. And then in relation to third party harassment in particular, some of you on the call, I won't ask you to identify yourselves, will remember when third party harassment was a thing first time round. And you'll recall that what that said at the time was there was a potential claim if, as an employer, you knew somebody was being harassed by a third party and it had happened a couple of times before and you didn't do anything to stop it. What the new legislation says in the new implementation of the Equality Act, a third party harasses someone in the course of their employment and you fail to take all reasonable steps to prevent it happening. Helpfully, the government have said that they will not consider the threshold to be as high because, of course, they recognise that you don't have the obligation to, the control over the third party in the way that you maybe do your own staff. It's all fine and good, the government saying that. It is not what the legislation says. So again, this is going to be a case of risk assessing. All reasonable steps. The problem with using the phrase all reasonable steps here is that all it takes is for an employee to come up with one thing that you haven't done, a tribunal to go, yep, that's a good idea, they could have done that, and there's a risk of losing the claim here. One potential way to circumvent that, or certainly to mitigate it, would be to involve the staff in the risk assessment process in the first place. We've done it. Our risk assessment for sexual harassment was circulated, particularly to those staff who spend a lot of time off site. So us at conferences, court hearings, wills and tax team who may go out to care homes, for example, where the individuals they encounter might not have the same level of control as others. And all of that has now been factored in, and we've engaged with staff to ask them what they would consider to be reasonable steps to try and mitigate the risk. That may be a good move if you're in the kind of workplace where, as the HR person, as the business owner, it may not always occur to you exactly what staff are doing on a day-to-day basis and where they consider the risks to be. All employers are going to be affected by this, but it will be particularly relevant, as I've said there, in areas such as hospitality, service, and where there's high interaction with contractors, suppliers, customers, members of the public. You're already taking steps, probably. Harassment clauses in your supplier contracts, the signs at entrances like you see in GP surgeries that say we won't accept it, the ability to terminate relationships. Our terms of business was updated to say that we won't accept harassment of our staff, and we reserve the right to disinstruct ourselves if it takes place, and ensure that reporting is encouraged, that reports are investigated promptly, seriously, and corrective action is taken. You may well also, as I've sort of indicated there, need to look at your commercial arrangements, and there is nothing wrong with approaching this similarly to how you did GDPR when that came in. You were asking third parties about their data handling provisions. There's no reason not to ask what a third party's sexual harassment policy and position is as well. I'm going to skip trade union rights because I'm conscious of time. If people, and I'm also conscious that that's not an area that's going to affect absolutely everybody, but the real simple basics of this, as I hope you've picked up all the way through, this is all about easier access to the workforce, to increase engagement, to increase membership. And I think, well, this isn't necessarily a move back to the level of power and engagement that we perhaps knew from the 70s and 80s. It's certainly a step back to probably more into the sort of 90s and that level of engagement, certainly before the last sort of 20 to 30 years where the balance has probably been much more in favour of employers on this. I think what you want to be doing, especially where you have a workforce that you know is already interested in unionisation, or you've already got partial membership, consider your engagement strategies now, because as I said earlier, a workforce that already feels like they are involved and feel represented are less likely to turn to a union to look for representation if they don't have to. I do think that's the underlying message here. It's carrot and stick, as I said earlier, in the expectation that it will lead to conversations, workplace representation, and internal collective bargaining. Right, finally then, the big one, and I know people are interested in this, day one unfair dismissal rights. Very quick reminder of the current law: employees only, 2 years continuous service to bring a claim for ordinary unfair dismissal. To lawfully dismiss as an employer, you must identify a potentially fair reason, conduct, capability of redundancy, statutory illegality, or mop up some other substantial reason, and follow a fair process. That is distinct from automatic unfair dismissals, which don't require a qualifying period, and it's a dismissal where the main reason or a substantive reason was related to something like pregnancy, maternity, enforcing a statutory right, whistleblowing, or exercising trade union rights. What the Employment Rights Bill does is make a couple of major changes to this. It removes the 2-year qualifying period. The House of Lords tried to introduce, or rather reduce, I suppose, it to 6 months. That was rejected. Day one rights was a flagship announcement for the government that seems very, very unlikely to change, subject to major political upheaval in the next 2 years. And ultimately what that means is for all qualifying staff, day one protection from dismissal without a fair reason or without fair process. That is, however, subject to the initial period of employment, otherwise often referred to now as the statutory probation period. It will be a formal probation period during which employers will be able to fairly dismiss an employee using what the government has called a lighter touch and less onerous procedure. I am banking on that being a 6-month process with the ability to extend to 9. That is still slightly subject to further regulations. And it will only apply to dismissals where the reason is conduct, capability, illegality, or the SOSR mop-up. Redundancy at the moment, subject to any change in future regulations, seems to be very clearly excluded from that. So just to be clear, redundancy becomes a day one entitlement on current drafting, and therefore staff will need to be included in redundancy consultations, even if they're day one. So what that means is no more safe short service dismissals after this kicks in without there being some kind of process or procedure. That reduced process hasn't been clearly set out yet, but it looks likely to include, as a minimum, a meeting with the employee, at which the Section 10 Employment Relations Act right to be accompanied will probably kick in, with a written outcome and following any codes of practice, so particularly for conduct dismissals, for example, there will still need to be some kind of process or procedure followed. I'm almost certain that ACAS will update and set out what they consider to be a minimum standard, what I suppose we continue to call short service dismissal, but it will now be subject to a procedure. All of the usual tests will apply. So it's still showing a genuine conduct capability issue. On the plus side, dismissal during that initial period of employment will probably have some kind of statutory cap. I can't imagine there's going to be much justification in saying that somebody who has been employed for 3 months is entitled to a year's salary, given that the majority of the claim, of course, is usually loss of earnings. So, what's the current guidance for this? What do you want to start thinking about? Well, firstly, enhance your pre-employment and recruitment process. We want to filter out people who are going to be a problem before they become one and before they acquire these rights. You want to update contracts, dismissal procedures. In theory, your contractual probation periods, insofar as they relate to contractual entitlements, could continue and may still continue to be relevant to notice periods. But realistically, you might as well merge contractual probationary periods with the IPE. Internal probation procedures will need to marry up anyway. This is a good opportunity to look at those probationary periods, to look at how they're being reviewed, and make it clear really that what we need is proactive performance management from day one. Let's be honest, the most common reason to dismiss early is because somebody simply doesn't fit or isn't good enough at the job. That is going to need to be made clear, documented, and with fairly robust forms of management and compliance to ensure that there is a review process during that IPE. You're not just going to be able to get to 6 months and go, let's have a meeting, we don't think you're good enough. You'll want to review grievance and appeal processes as well, of course. There's nothing to say this won't apply to a constructive unfair dismissal. And the other thing I would point out briefly is data retention periods. Some people will have data retention periods that relate to the limitation period for claims. This, of course, will mean that there are day one rights, so the limitation period will apply even to people who have been dismissed on short service. Don't forget that limitation period by then will be 6 months. So if you're keeping things for, say, 3 years plus 6 months, 3 months at the moment, sorry, that will become 3 years plus 6, just as an example. As this gets closer, once we know what the regulations actually look like and how things will actually play, we will obviously do updates on these. But again, this is a good opportunity to start planning a couple of years in advance as to what this process is going to look like. And ultimately, I think the thing to take away from this is more people have more rights from day one, and there is a risk assessment at corporate level that needs to be undertaken about these. I think the best way you can mitigate this risk is by introducing those processes and procedures, and ideally really tightening up the recruitment process to ensure that competency-based recruitment is really increasingly the focus. I have somehow managed to finish going through that with literally just under 1 minute to spare. So before I come on to any questions, next session, remember, 5th of November, and I'll be looking at the increasing use of AI systems in the workplace, which hopefully will be a really good session. It's one I've had a lot of people ask me about. I don't pretend to be an AI or IT expert, but I will look to bring somebody on board to at least talk about the technical side. I will stop there. I appreciate we've just about hit 11 o'clock. If there are questions arising, I will carry on for a short while. But for those of you who need to go, thank you. We'll see you next month. Please enjoy the rest of your day, the rest of your week, the rest of your month. And as always, I will see you on the next session.